Welcome to Constitutional Defenders, where we discuss important issues and cases related to criminal defense and how criminal defense attorneys handle these cases on a daily basis. Today, we'll be speaking with CannaBusiness Attorney Bob Hendricks, who will help us navigate the laws surrounding the cannabis industry and recreational use. Welcome to Episode 2. Welcome back to Constitutional Defenders. Today we have not only myself, but Takura Fakudza and Mary Chartier, our hosts. How are you guys doing today?
We're doing great. Thanks, Lizzy.
Hey, Lizzy, how you doing? Thank you for having us.
Doing good. Morning's been good so far, other than Chance, my dog, Lenny, to mole to death this morning, unfortunately. I know.
He loved it, Mole, so much.
Yep, he just wanted to play with it so bad and hug it, so R.I.P. Mole.
Poor Mole.
I know.
No.
So what have you guys been up to?
Well, as you know, we started a fitness challenge at work, and I am committed to getting fit, and I can barely get out of my chair because I'm so sore. So that's what I'm up to, walking like a really old lady as I try and move around this office.
Well, I too have been trying to move with a sense of purpose as she zips around the office past my door.
Mary has been jogging back and forth between the offices.
I have. I got to get my steps in. I got to get my fitness in.
Nice. So who do we have with us today?
So today we have Robert Hendricks. He is a fantastic lawyer at Warner, Norcross, and Judd. Bob has been a business lawyer for many, many years. And for the last, let's say, 8 or so years, he's been focused on CannaBusiness. And he is instrumental in helping many businesses get their license and guide them through the CannaBusiness industry. He also is the chairperson of the State Bar of Michigan's Marijuana Law Section. I am the former chairperson, and that's how Bob and I met, along with some other great folks. And we're just thrilled to have him here today to educate us on what's going on with the new recreational law in Michigan.
Awesome. So we've got Bob on the line.
Hi, Bob. We're so happy to have you on today. As you know, our topic is marijuana. So what's up with weed?
What's up with weed? You know, every day in marijuana land, things change a little, things evolve a little. Things will surprise one a little bit. And I think that all told, things are happening in Michigan in a positive way.
Bob, with the passage of the Michigan Regulation and Taxation of Marijuana Act, which we all affectionately called MRTMA, what's the landscape look like? Do we have businesses that are ready to open? Are they open? What is that landscape?
We do not have any businesses that are open under the law. I think there are a lot of businesses who are champing at the bit and are ready to the extent that they know what ready means to get moving. What will happen next in Michigan is that on November 1, 2019, the Marijuana Regulatory Agency, which is a division of the Michigan Department of Licensing and Regulatory Affairs, the Marijuana Regulatory Agency will begin accepting applications for licenses under MRTMA. So that will be the next step in the kind of evolution of the effectiveness of MRTMA. Right now, under MRTMA, citizens over the age of 21 years may possess and use marijuana without a patient card. So that component of the law is effective. But the commercial outlets for the growth and the processing and the retail sale of adult use marijuana won't start until after November 1.
Thank you for clearing the fog, or the haze, as others might say. But,
Takura's making weed jokes this morning.
Bob, what does this mean for what most people know as dispensaries going forward?
Well, it means that there will be, in all likelihood, more dispensaries throughout the state of Michigan. Dispensaries are the retail sellers of marijuana, and currently under the Medical Marijuana Facilities Licensing Act, we have what we call provisioning centers They are the equivalent of dispensaries. They're the retail outlets for for medical marijuana retail sales to patients and caregivers. We have those now. We don't have a lot of them. I think probably at last count there were about 100 provisioning centers for medical marijuana scattered all around the state of Michigan. Once MRTMA becomes effective and licenses begin to issue, we will likely see a continued increase in the number of those retail outlets. And interestingly, under the rules, the emergency rules that were promulgated just a few weeks ago by the Marijuana Regulatory Agency, we may see a combination of both medical marijuana and adult use marijuana retailers in one facility.
Bob, is it called a provisioning center under MRTMA or a dispensary?
Well, it's actually called a marijuana retailer under MRTMA.
Okay, yet another new term for us to learn. So it's called a marijuana retailer. Would someone go into, for example, Bob's marijuana retail shop, and there would be an area for medical marijuana and then an area for retail marijuana or recreational marijuana?
That's exactly how I read the new emergency rules, that the regulator is going to at least consider authorizing the co-location of medical and adult use retail in one facility, but there will have to be a division of the inventory and a separate accounting for and tracking of the medical and adult use inventories.
What would be the benefit, Bob, then, of getting your medical marijuana card and paying for that fee? What would be the point of getting that?
Well, there is a different tax structure for medical and adult use marijuana, so that would be one difference. In addition, and this is where I am not an expert at all, but I will tell you that as I understand it, there are certain advantages in having a medical marijuana card in terms of potential criminal liability for certain kinds of activities. And so I think what we're going to see is just kind of an assessment over time of whether there will be a continued value in having a medical marijuana card. Also, I know from lots of other states' experiences that some medical marijuana users value that status and see that status as very different than users of marijuana who use it for recreational purposes. And so there may well continue to be an interest among some medical marijuana patients in having that card and having a physician kind of involved in their assessments of their medical conditions.
It sounds like you don't think that we'll see the Medical Marijuana Act going away just because people aren't using it.
No, I think there will likely be a decline in the number of patient cards. There may be a decline in the number of caregiver cards. But I think that medical marijuana is a real thing, if you will, and that it is likely going to continue in under Michigan law for some time into the future.
Will there be a difference in products? For example, a person goes into Bob's hypothetical retail outlet. Will there be medical marijuana products in one area and recreational marijuana products in another? Will there be a difference in products? So, for example, maybe stronger?
Well, I think it's too early to know that for certain. I think in some ways the development of particular types of products will depend on how the market responds. So I think there certainly will be the potential for some different kinds of products. But I think it's too early to know.
Now, Bob, at present count, you said we have about 100 provisioning centers scattered throughout the state. Will these exist in every county or township throughout the state once MRTMA takes effect and that November 1 date hits?
Like the Medical Marijuana Facilities Licensing Act, MRTMA also gives a fair amount of local control to local municipal authorities. And municipalities under MRTMA are defined the same way they are under the MMFLA. They are cities, villages, and townships throughout the state of Michigan. And at last, I think there are about 1,750 of those municipalities throughout the state. under the MMFLA, a municipality was required to adopt an ordinance authorizing marijuana activity in their jurisdiction before the state would issue a medical marijuana license. MRTMA changes that process by 180 degrees. What MRTMA says is that a municipality may opt out, but if they do nothing, then the state can issue an adult use license to an applicant without getting the municipality's consent. So what we're going to see in all likelihood is some municipalities will decide either now because they don't exactly know what the system is going to look like, or maybe more permanently, they will decide that they do not wish to have adult use marijuana establishments in their jurisdictions. That doesn't mean that adults may not use marijuana in those jurisdictions. What it means is that you will not have commercial marijuana establishments in any municipality that opts out.
Imagine that we have a town, let's call it Lizzyville.
Oh, that sounds wonderful.
That sounds like a wonderful town. Lizzy loves that, just like Pawnee and Parks and
my
Rec.
favorite.
We have a town, Lizzyville. The council in Lizzyville, they do not want any marijuana establishments. That does not mean that the town can restrict people from using. It just means that there wouldn't be any marijuana establishments. Is that what I'm hearing, Bob?
Precisely what you said, yes.
Great.
Long live Lizzyville.
That's right. Long live Lizzyville.
And Lizzyville could also say, look, we would allow testing labs and transportation, secured transporter facilities, and growers, but we don't want processors or retailers in our jurisdiction. They could adopt an ordinance like that.
We talked about marijuana retail establishments under MRTMA, but there are actually other businesses as well, right, Bob, that are springing forth because of MRTMA?
It's true, and the new rules, the emergency rules, establish 2 or 3 additional types of licenses that will be available under MRTMA. The consumption establishments, whatever that means, is one of those new types of licenses that wasn't explicit in MRTMA, but is authorized by MRTMA if the regulator chooses to create that class.
When you say consumption establishments, do you mean like the coffee shops that they have in the Netherlands where you can go in and enjoy marijuana?
That's exactly what I mean.
Oh, look, Takura's all excited about that. He's thinking road trip. He's about to get in his car right now and go
on to Netherlands.
So, Bob, any idea how cheap or expensive these licenses are? I know when I go and renew my license at the Secretary of State, it's, I don't know, like $15 or something. Can I expect to pay the same, or will my bank account have to be heftier?
$15 at the Secretary of State. I think I pay way more than that. I think I've got to go with Takura to get the discount. Right, the mayor of Lizzyville has to pay more than that. How are you paying that low amount?
The mayor of Lizzyville pays like $150, not $15.
We need to go and renew with Takura. That's the end of this, right? That's what we need to do.
Yeah, your bank account will be affected, Takura. The application fee for an adult rec license will be the same fee as exists under the MMFLA. That is, when you file your application with the state of Michigan, you'll pay a $6,000 application fee. Now, under the MMFLA, most licenses were assessed what they call an annual regulatory assessment. I say most because the testing labs were not subject to an annual regulatory assessment. All the other license holders were, and the license last year, the regulatory assessment last year was $66,000 annually, except for Class A growers. That annual regulatory assessment is capped in the statute at $10,000. Under MRTMA, There will be an annual regulatory assessment for most license categories, but those numbers are significantly lower than the medical regulatory assessment.
So are you
like in the $6,000, $8,000, $10,000 per year.
Are you finding as a CannaBusiness attorney that people are using lawyers to get through what appears to be a fairly complicated process, or are they trying to go it alone?
My experience is that while a few applicants for licensure have handled their applications completely by themselves without the assistance of counsel, in most cases, when the applicants begin to look at the rules and the forms and the application process, they decide, I better seek somebody who can help me through this complicated process. So we're continuing to see a fair number of people coming to us and requesting our assistance to put together the license application itself. In the case of the MMFLA licenses, there's a two-step license application process, or a process that can be divided into two steps. The first step is pre-qualification, where the focus of the regulator is on the qualification of the applicant for licensure. Do they meet the statutory criteria? And then the second step is more like applying for a building permit, where you have to demonstrate that you've got an appropriate design and you meet the zoning criteria and you've got a security plan and things like that. And many applicants do much of that step two work themselves or in consultation with engineers and architects and other experts.
Are people getting rejected?
People continue to get rejected. The transparency of the reporting of rejections is a lot different now that we don't have the board. As you all may recall, when the MMFLA was first established and the process began, there was a 5-person board appointed by the governor, which reviewed every single application for a medical marijuana facility license. And they did that once a month. There was a public hearing that was live streamed, and you could actually watch each of the names of the applicants go before the board, and they would decide whether they would approve them or deny them. That process has changed. It changed earlier this year when the governor issued a kind of a change in the structure of the regulatory agency, disbanded the board, and now the MRA, the Marijuana Regulatory Agency, it considers these applications, and it does it on an ongoing basis. They don't have a monthly meeting that's televised. They just consider applications as they're ready for consideration. I have certainly heard of applications being denied, but I think the number of denials is significantly lower as a percentage than it was under the old board.
Are you seeing people still apply under the Facilities Licensing Act to be provisioning centers for medical marijuana, or are people now exclusively applying under MRTMA, and will we eventually see the Facilities Licensing Act go away?
I think that applications for licensing under the Facilities Licensing Act will continue for a variety of reasons, including, most importantly, that for the first 2 years that MRTMA is operative, in most cases, you are not eligible for a MRTMA license unless you already have a medical facility license. So that in and of itself will drive the continuation of medical marijuana facility applications. And then in the future, as we talked about earlier, I think there will continue to be a viable medical marijuana marketplace in Michigan, so there will continue to be applications for medical marijuana licenses.
So it sounds like this is not a cheap business to become involved in. Just looking at other states on an annual basis, on average, how much have the local and state governments produced in terms of revenue from the marijuana business?
Boy, Takura, I don't know off the top of my head what those numbers are. I think that the tax revenues are real. That is, they amount to real money. The way the regulatory, frankly, Michigan has the second largest patient count of any state in the nation, second only to California. We have over 300,000 patients who have patient cards in the state of Michigan. And if those patients use their cards to acquire medicine, it doesn't take very long to get the annual sales of medical marijuana up into the tens or hundreds of millions of dollars, and then you apply the sales tax to that, and you're talking about real money.
And the jobs, are you seeing some areas that are very welcoming to marijuana establishments because they believe it will bring employment opportunities to their community?
Absolutely seeing that, Mary.
We talked about retail establishments, provisioning centers, dispensaries, whatever they may be called. Are there other businesses? You mentioned Class A growers. What's that?
Yes, so under both the Medical Facilities Act and under MRTMA, there are three classes of growers, the Class A, Class B, and Class C growers. In the MMFLA and in MRTMA, the numbers associated with those classes are a little bit different. Under the MMFLA, it's 500 plants, 1,000 plants, and 1,500 plants, dividing the three classes. Under MRTMA, it's 100 plants for a Class A grower, 1,000 for a Class B grower, and 2,000 for a Class C grower. And then under MRTMA, there's also another class of grower called a microbusiness. And a microbusiness is authorized to grow up to 150 marijuana plants, to process those plants, if the microbusiness chooses to do so, into derivative forms of marijuana, and then to sell the products at retail directly to consumers over the age of 21. They can't sell the product into the adult use marketplace other than directly to consumers. But that grow business or microbusiness seems to be very attractive to a lot of people who want to enter the marijuana industry.
Do they open up their own storefront? Can they do it out of their home? How does that work?
Well, I think it's going to depend. We haven't seen any yet, Mary, because
Okay.
we haven't seen the applications begin to be considered and to be granted.
Well, I want you to look into the future, Bob. I want you to pull out your crystal ball and predict what's going to happen. Let us know the lottery numbers. Come on, Bob, you can do that.
What I envision, and maybe this is a little narrow, but certainly one of the ways in which I envision the microbusiness will exist is much like a farm stand. A rural community, a marijuana grower puts up a small greenhouse on her property in a rural community and grows 125 marijuana plants, harvests the plants, and maybe has a small storefront in the front of that facility where consumers may come and directly purchase their marijuana from that microbusiness owner.
Sounds like farmers markets may be seeing more foot traffic.
Yeah.
Do they have to get those products tested at the lab?
Yes, they have to be tested.
There'll be no marijuana sold, not at a micro business or a retail establishment that has not been tested at the lab.
You know, I think, and that is one of the most significant components that our regulator focuses on, is the importance of testing. They really, really are very interested in making certain that the consumers of marijuana in the state of Michigan have access to product that has been tested.
And what are they testing for, Bob?
Oh, golly, they test for the presence or absence of contaminants, both organic and inorganic contaminants. They test for pesticides and herbicides. They test for a lot.
I think a lot of people choose marijuana because it's natural, and it's more natural, certainly, than the prescription drugs that they may get from a doctor. I think a lot of people want to make sure that there are no herbicides or pesticides in it. I think the testing phase is a real step forward for the state of Michigan to make sure that people are consuming things that are natural for their bodies.
Yeah, and I know just from ongoing interaction with our regulator that they are very, very interested in preserving and really enhancing and ensuring the continued viability of testing, because they think it's so important for consumers to have access to tested marijuana.
So will there be labeling so someone will know the amount of THC or CBD in a product, sort of like a truth in labeling aspect of the law?
Yes, which I think goes hand in hand with the testing, the emphasis on testing at the regulatory level. They really want to be sure that consumers know what they're getting.
Sounds like this effort is not half-baked.
Oh, no.
Lizzy, edit that out. Edit that out. That's too punny for us. Bob, we talked about a grower, a micro business, the retailer, a testing lab. But what about a processor? What does the processor do? Do they get the marijuana from a grower and then send it off to the lab or the retail establishment?
Yes. Now you can have vertically integrated businesses where a licensee holds both a grower license and a processor license, and that person when they have their grower hat on, they grow the marijuana, they harvest the marijuana, and then they deliver it to themselves. They put their processor hat on, and the processor will process the marijuana and essentially turn it into derivative forms, whether that be a tincture, an oil, a capsule, whatever. And I think, again, as we see this newly developing industry continue to mature, we're going to see more and more different ways in which marijuana is processed into derivative forms. But a processor does. They turn it into some derivative form that's available for consumption.
One of the issues under the Michigan Medical Marijuana Act had been the issue of tinctures and oils, and it was somewhat of a gray area in terms of how much a person could have. It sounds like that has been addressed under MRTMA with a specific amount for people to have. Is it 15 grams?
I believe it is 15, yes.
You also mentioned a secure transporter. Those people need to be licensed to transport marijuana from one location to another?
Yes.
So we won't see a truck with a bunch of marijuana plants in the back waving and back and forth going down the street?
Yeah, there's the ways the secured transporter role in MRTMA is handled is a little bit different than under the MMFLA. Under MMFLA, virtually all transportation of marijuana between and among the license holders has to be done by a secured transporter. Under MRTMA, if a grower chooses to move a very small amount of marijuana, they can do so without a transporter. But generally, in commercial quantities, you will need a secured transporter to move marijuana.
Bob, this might seem like a silly question, but for our listeners who don't know, what is CBD?
CBD is an acronym derived from the word cannabidiol. I'm not a botanist and I'm not a chemist, but as I understand it, cannabidiol is one of a number of derivatives of the cannabis sativa plant. Cannabidiol, CBD, is based on everything I've read and the popular conception, it is a non-psychoactive component of the cannabis sativa plant that may have many medical benefits. So CBD has become super attractive and popular in the marketplace because it doesn't have the psychoactive components. It doesn't get you, quote, high, but it does appear to have some medical benefits and some other benefits, physiological benefits, that cause people to be very interested in CBD.
Yeah, actually, I was recently traveling, and in Wyoming, I found it interesting that one of the three options that people had for coffee were sugar, creamer, and CBD.
That's right.
It's so interesting because the marketplace and the popular demand seems to have far outstripped the legal and the regulatory framework within which CBD is becoming available. The FDA's kind of explicit position is that the addition of CBD to beverages is not lawful. And yet you see it everywhere.
Everywhere.
And nobody seems to get into any trouble. Now, the people who are getting in trouble over CBD appear to be the folks who make extraordinary claims about efficacy, medical efficacy. CBD will cure all forms of cancer known to the human condition. If you're making claims like that, you're likely to get a cease and desist letter either from the federal food and drug regulators or possibly from your state regulators.
Well, they're even selling CBD at places like video stores. I was out of town for work, drove by this video store, and I won't say the name, I don't want to out them, but they had a big sign that they were selling CBD products there. And is that lawful, Bob, or is it really just folks looking the other way?
I think it's a case of people looking the other way. There is so much lack of clarity between the new laws that have developed in the past 6 or 9 months, the Farm Bill at the federal level, state laws in a variety of states addressing industrial hemp and CBD. There is so much lack of clarity in precisely what is allowed, what's not allowed. CBD, for example, is a derivative of the cannabis sativa plant. If the cannabis sativa plant from which the CBD is derived has a dry weight THC content of less than 0.0 or 0.3%, then it's not marijuana under federal law. If it comes from the cannabis sativa plant that has more than that percentage of THC, then it is marijuana. And yet it seems like CBD is CBD no matter what kind of plant it comes from. So there's a lot of confusion.
What's interesting about that video company, and like Mary said, I will not out them, although I did used to work there at one point in my life. The company, as far as I remember, is pretty conservative. So it was kind of a shock to me when I saw that they were selling CBD. I don't know if it's to, attract a younger crowd or stay afloat. I'm not sure.
Well, they may be conservative business owners, but they also, don't they sell a lot of porn there? So, Lizzy?
Yes, that's true.
Right. So in between the porn and their videos, they've got CBD, which is a good thing. They like green. They like money.
Exactly. Green is green.
Green is green, whether it's money or weed. They're happy business owners.
Good one. I see what you did there.
It certainly seems like the attraction of CBD is not limited to young people or people who like marijuana. CBD seems to be super attractive to almost every different segment of society.
My grandma uses it. Sorry, Grandma, to out you on the air.
You have a cool grandma.
Yeah, I do.
Yeah.
So this is a funny story. So we have a family member who lives in another state. And she's a very lovely woman, but she's very conservative. And she suffered from some very serious health issues. She was telling me she felt much better. Her doctor had recommended a product. She orders it from Colorado, had something in the title called like Green Health, and she's been taking it and she feels so much better. So immediately I'm Googling this, and I don't want to tell her it's marijuana because I'm afraid she'll stop using it. But as soon as we hang up, I turn to my husband, Jeff, and I'm like, hey, so-and-so is using weed, which is remarkable because she's the sort of person who would be very critical on that. But you see the broad base of people who are benefiting from the health impact of marijuana.
Yep.
Now, Bob, one of the things I find to be very curious is the federal government claiming that there's no medical benefit whatsoever from marijuana. It's a Schedule I controlled substance, but yet also holding a patent in which they tout the medical benefits of marijuana, right? Classic federal government with this crazy dichotomy. Do you see any relaxation at all by the federal government in terms of their philosophy on marijuana use? Now, Bob, one of the things I find to be very curious is the federal government claiming that there's no medical benefit whatsoever from marijuana. It's a Schedule I controlled substance, but yet also holding a patent in which they tout the medical benefits of marijuana, right? Classic federal government with this crazy dichotomy. Do you see any relaxation at all by the federal government in terms of their philosophy on marijuana use?
I do. Now, if you ask me to predict precisely when we will see a significant shift in the way the federal government thinks about marijuana, I can't make that prediction. But one of the reasons that I think it is inevitable that the federal government will come to deal with this is that we now have 33 states in the United States of America who have authorized some form of medical use at the state level in their jurisdictions. We have 11 states plus the District of Columbia that have authorized full adult recreational use of marijuana. So what we have is a whole bunch of senators and representatives in the House of Representatives in Washington, D.C., who represent states where marijuana is legal under state law. And I think it's only a question of time before they finally reach that critical mass level where they say, we just can't make sense of this division between federal prohibition and state authorization and all the consequences that flow from that, the banking consequences, the income tax consequences, and lots of, the patent and trademark consequences. We can't continue to suffer the consequences that are resulting from a robust, growing state law authorized marketplace and federal illegality. It's just schizophrenic.
And I think, to be clear, marijuana is currently a Schedule 1 drug, Schedule 1, and that's even higher than cocaine.
Right.
Marijuana is a Schedule 1 controlled substance. It's among just a few Schedule 1 controlled substance. And interestingly, one of the three criteria applied to determine where a drug, a controlled substance, will be on that class or schedule is whether there's any medical efficacy. Class 1 controlled substances supposedly have no medical efficacy, and Mary is exactly right. The same government that says that marijuana has no medical efficacy is the holder of a patent for marijuana used in medical treatments. It's kind of crazy.
It's totally crazy. It's totally crazy. I feel like this is very similar to alcohol prohibition, where ultimately the country came to its senses, thank goodness, as a big red wine drinker. And now we have this awakening as it relates to marijuana. I don't see the federal government being able to turn back the hands of time. It appears that we're just going on a particular trajectory where marijuana will ultimately be legal across the board.
Yeah, I think that's right. And interestingly, it may be the popular approval and acceptance of CBD that eventually pushes this thing down to the point where prohibition is just repealed. Because so many people who maybe aren't, Mary, to follow up on your example, maybe aren't fans of marijuana or they think it's a bad thing, they still are very interested in and approve of the use of CBD. That may eventually be what brings us to the point where prohibition at the federal level is repealed. I read a great book a few years ago called Last Call, and it is a book, not a nonfiction book, about the development of and then the repeal of the prohibition of alcohol. And the similarities, at least from my vantage point, were remarkable.
I read an article yesterday. It hasn't become law yet, but there's a bill in the works for the expansion of expungement here in Michigan for offenses that there once was a time when people could not have marijuana in their possession unless, of course, they were medical marijuana patients. But now there's a move to expand the types of convictions that people can have removed from their record if current law would make it legal.
That's so important. Convictions are so problematic for people trying to get jobs, housing. I think that's so important, and I hope that passes soon.
Yeah, I'm with you there.
Bob, what are you hearing from communities that don't want any marijuana businesses? Are there still some stereotypes or misconceptions that people have that you're hearing?
Yeah, right now, those communities that are opting out of MRTMA, generally, the rationale that they articulate for that decision is, well, we haven't seen the rules yet. We haven't seen kind of the regulatory framework within which this is going to be rolled out. And so as a matter of precaution, we're going to adopt an ordinance that prohibits that until we see what actually happens. That is by far the most common reason that I have heard for municipalities to not opt in.
It's still illegal for young people who are under 21 unless they have a medical condition and have their medical marijuana card. It's a civil infraction, but Bob, it's still illegal for those under 21 to possess, correct?
That is absolutely correct. The rationale for that seems to be that there's a fair amount of evidence out there that marijuana is an intoxicant. It is not a benign substance. It does have effects, and some of the health effects that the medical community is studying is the possible effects of marijuana use on developing brains. I don't think we have kind of a decisive and definitive understanding of exactly how that works, but I think generally legislators and regulators are cautious about making marijuana available to young developing brains at this point. Maybe we'll see a change in the future as more and more medical research gets done, but you're exactly right, Mary, that unless you are a medical marijuana patient with a card that's based on a recommendation of a physician, if you're not 21 years of age, it's not lawful to use marijuana.
We've argued a couple of cases on medical marijuana at the Michigan Supreme Court, and one government lawyer said, we certainly don't want to see marijuana businesses on Michigan Avenue headed to the Capitol. And my response was, are you afraid it's going to distract from the strip club and the bars that are on that street? And I mean, so much easier to explain that people use marijuana just as they do alcohol or as a medicine, rather than, hey, there's naked ladies giving lap dances in there. And it's a lawful business. And so I'm not criticizing, but there seems to be this stigma around marijuana. Bob, are you seeing anything from other states that Michigan residents should be concerned about? Increases in crime, anything like that?
Mary, there's so much information about this burgeoning industry that it's very difficult to keep up with precisely, what statistics are arising out of which state. But I will tell you that my sense is, anecdotally, and based on some fairly well-developed studies now, that the legalization of marijuana in particular states has not led to any increase in crime or the increase of youthful use of marijuana. And in many cases, it's had just exactly the opposite effect, a reduction in crime and a reduction in youthful use of marijuana. That seems to be the lay of the land.
Now, Mary, this is a question for you. It has, well, at least to this point, has not been legal to drive under the influence of marijuana. Will it be going forward?
No, it's not lawful to drive under the influence. What's interesting is the varying standards of operating. So if you don't have a card in the state of Michigan under the Michigan Medical Marijuana Act, it was a per se standard. If you had any amount of active THC in your system, then you were violating the law if the prosecutor could prove that at trial. So even 1 or 2 nanograms, theoretically, although there have been some great challenges to whether that's scientifically valid, whether that's truly an accurate level that has been detected in a person's blood. So if you were a non-card holder under the Michigan Medical Marijuana Act, you could have no level of active THC in your system. If you were a card holder, then the standard was under the influence, which means a substantial and material effect on driving. We actually handled the People versus Kuhn case along with a great lawyer named Matt Newberg at the Michigan Supreme Court, and we prevailed.
Whoop, whoop.
Yay! Right. So the standard for card holders has been marijuana in a person's system cannot have a substantial and material effect on driving. That same under the influence language that existed and does exist in the Michigan Medical Marijuana Act also exists in MRTMA. So the prevailing notion is those phrases mean the same thing because as lawyers, we know that when you're using the same terminology, it's presumed to mean the same. So there has not been a case that has gone up to the appellate courts yet. MRTMA is so new. But the prevailing notion is, again, that it will mean substantial and material effect on driving. What's interesting is under the former governor, there was a commission, an impaired driving safety commission convened, predominantly law enforcement, government folks, not a lot of defense lawyers. And their viewpoint was that a per se standard, 5 nanograms, 10 nanograms, anything like that, was not supported by science. It's a fascinating report to read for anyone who wants to go online and take a look at it. It really details why we want to make sure that our laws are based on sound science, And this under the influence standard has been operating for years now in the state of Michigan with the substantial and material effect on driving, and has been very effective.
Now, Mary, I went to law school.
Well, that's good, because you are my business partner in a law firm. So.
We would hope that you had that background.
I'm not a big fan of science. Now, does that per se standard not make sense? Because, for example, I could have smoked a week ago, and depending on the potency or even the composition of my body, it may not leave my body at the same rate as it does another person.
You're right that marijuana will leave different people's bodies at different rates, but you're not going to see active THC a week after someone has ingested marijuana. What you would see would be the waste product, the carboxy, the metabolite. That's what people are seeing when they're tested a week after ingesting marijuana or 2 weeks after. That's frequently what you see when someone is on probation or there are bond conditions, and then they look at a lab report and then they see the carboxy level. That's very different than active THC. There's a case out of the Michigan Supreme Court called People versus Feezel, Feezel, and that does a great job with delineating the difference between active THC and the carboxy level, which has absolutely no impact at all on a person's impairment level. So if a person has a 45 nanograms of carboxy THC, that has no impact on driving, on any sort of ability. It's the waste product. And so what the concern is about a per se level is that marijuana will leave people's bodies differently, of course, but also, for example, if a person has 4 nanograms in their system, if the individual is a regular marijuana user and a longtime marijuana user, that is going to have a very different impact than someone who is an occasional or a first-time user. We don't have that direct correlation that you see with alcohol. Alcohol, it's not perfect, but it's very different than it is with THC. The reason a per se standard doesn't work is every person is going to be different. So you cannot set a per se standard and then expect that you'll be able to equate that to a low level of impairment. The science just isn't there. I love science. Our fabulous producer and the mayor of Lizzyville, she also loves science.
I love brains.
She loves brain science. I know. She's like our little zombie. But the science just doesn't support setting a per se standard of any amount for THC.
So what you're saying is it's not feasible.
That's a good one. That's a good one.
When you were initially answering Takura's question, Mary, you talked about active THC. And I didn't know, is there a time limit? Is it 48 hours, 72 hours?
Active THC will leave a person's system very quickly. It's the metabolite, the inactive, that stays in a person's system for weeks, if not months. And that's the part that a lot of people don't understand. Even a lot of judges don't understand it. So what you'll see a lot is someone go, for example, on probation or be on bond conditions, and a judge will say, I want to see these levels drop. But that's not how it works. I mean, the science doesn't support that. Someone may test negative one day for the carboxy level, the metabolite, and then the next day they might test positive for it. It's not necessarily indicative of recent use. So someone who has a lot of fat cells in their body, which today I'm starting the C&N fitness challenge, so hopefully in 3 months I will have less than I do now, will be storing THC more than someone like Takura, who's the most physically fit person on the planet, because he just doesn't have the same number of fat cells. And it's just body composition. A person who's working out a lot, they're losing weight, or a person who works in a job like construction where they're very active, the way that the carboxy will leave their system will be different than, for example, someone who's more sedentary. Longtime users, people who use quite a bit, it will remain in their system longer. So what we frequently see in court are judges trying to interpret the results when they're looking at the inactive THC level in a person's system and trying to equate that to someone using again or a recent use. And it's not something that a lot of people are familiar with. When someone has a case like this, you need to either bring in a scientist or bring in a lawyer who understands the science, because you have people jailed because a judge looks and says, well, yesterday you tested negative, today you test positive for the carboxy. That has to be indicative of recent use, and it doesn't. That the science just does not support that.
I believe in one of the studies that I found for one of our cases, I know it said that it can stay up in your system for as long as a month, 2 months. But I believe there was even one case where it was past 90 days because the person had been a user for pretty much every day for like 10 years. Wow. So, I mean, that's a really long time for it to stay in there, but it's possible.
It is. And that would be more unusual, definitely that 3-month mark. But there are studies that really support more people than not for the days, the weeks, sometimes even months, with it remaining in a person's system. And so science, again, we love science here, but it's really important that people understand the science, because the impact of going to jail, being falsely accused of reuse, is extremely detrimental to people. I mean, we've known people who've lost their jobs, their housing, because of an allegation of reuse when it just was not supported by science. What's interesting is I was recently on a panel where we presented to the Michigan District Judges Association, and on the panel was a prosecutor and a law enforcement individual from Colorado. And the law enforcement officer and I agreed that the science does not support a per se standard. And we were both in agreement that in these OUID cases, which stands for operating under the influence of drugs, what is most compelling to a jury would be the officer's testimony about what they witnessed in terms of driving or the interaction with the driver. Bringing in a scientist to talk about an arbitrary nanogram level really is not effective. They're not seeing that effective in Colorado, and it certainly isn't effective in my experience as well. What really is more compelling in these cases is the officer's testimony, and then obviously the defense lawyer tries to refute the officer's testimony.
Interesting. That makes sense.
Bob, under the Michigan Medical Marijuana Act, you could not share marijuana with another patient or person unless you were the individual's caregiver. Is that correct?
Yeah, and yes, that's right. The way I try to think about marijuana in the state of Michigan is I start with federal prohibition and state prohibition, and then I look at ways in which changes in state law have authorized certain kinds of activity. And under the MMMA, a person who possessed marijuana could transfer that marijuana to a person who was their patient. Period.
That's it. That patient-to-patient transfer was a case up at the Michigan Supreme Court.
Oh, McQueen?
Yeah.
Does that ring a bell? Something like that?
It does ring a bell. That's a case that we argued, again, with the great Matt Newberg,
yes,
a very good friend of ours and a great lawyer. And thanks for bringing that up, Takura, because we won a portion of that case, but we lost a portion of that case. And this is the portion that we had lost on, patient-to-patient transfers. So when I would teach marijuana law in a law school class, I would tell them, sharing is not good. Sesame Street may have told you to share, but not with your marijuana. Patient-to-patient transfers were prohibited. That's different under MRTMA now, though, right, Bob?
As long as the sharing does not have a profit motive, that's absolutely correct. And as long as the amount shared does not exceed the maximum amount, which I believe is 2.5 ounces. So, Mary, if you and I are together and I decide to share a little bit of marijuana with you, and I don't ask you for money for that purpose, and it doesn't exceed 2.5 ounces, it's perfectly lawful under MRTMA.
You'd be a good friend, Bob. Thank you so much for sharing your marijuana. Sharing is caring,
That's
as
right.
Takura likes to say.
Yes, indeed.
Sharing is caring. Bob, thank you so much. You are an amazing resource, a fantastic lawyer, and a great friend. It has been so helpful to everyone to have you on today. Thank you so much for your time.
Yes, thank
Bob, you rock.
Thanks, Bob.
Every opportunity I have to get together with you guys, whether it's on the phone or by Skype or in person. Thank you.
Thanks, Bob.
Have a great day.
Okay, bye-bye.
Bye.
Bye-bye.
Thank you all so much for listening to our second episode. I hope that you were able to learn a little bit about CannaBusiness and that area of law.
I know that this was a highly anticipated episode.
Takura continuing on with the puns. Make sure you go and rate and review us on iTunes or Google Play or Spotify, one of the many platforms that we're on. And we hope to have you on our next episode listening away. So thanks, everyone.
Bye-bye.
Thank you.